Hi, Dr. Arnold.
Oh, hello.
I don't know if you know,
Hmm.
if I make you co-host, can you share your slides?
I should be able to, yeah.
Okay, let me just do that now then. Oh, also, are you okay if I record this event?
Sure.
Um, okay. I think we're just gonna wait 2 more minutes for everyone to join and then we can start.
Sounds good. I will try to get my slides up to make sure there's not any. All right. Did it work? Can you see them?
Yeah, I can see the slide.
All right. I usually have is it actually going through? Half the time it doesn't actually. Okay, great.
Yeah. Okay, I think we're going to get started. So, hi everyone. I'm Ashley from Women and Minorities in Economics. I'm the VP of Research. Later, we'll be joined by the president, Genevieve. She's running a little bit late, but today we have Dr. Arnold here to speak about racial discrimination and bail decisions. I'm going to ask everyone to hold their questions until the end. We'll let Dr. Arnold first go through all his slides and then questions. Okay.
All right. Well, thanks for inviting me here to talk. This is my first, quarter here at UCSD, so it's good to get involved with this group. And I hope you enjoy the talk. So today I'm going to be talking about racial discrimination and bail decisions. And so we kind of know that large racial disparities exist throughout the entire criminal justice system. So if you go from the beginning, Black individuals are more likely to be searched, to experience police use of force, to be detained before trial, and then all the way to be incarcerated. So today we're going to take, kind of one step in this criminal justice system and really focus on racial disparities in pretrial detention. So this is a kind of an area of the criminal justice system you might not be as familiar with, but it actually has huge consequences for individuals. So today I'm going to talk about a few different papers studying the source of racial disparities in the bail system. And so this is based on joint work with Will Doby, Peter Hull, and Crystal Yang. So before getting into kind of looking at racial disparities, it's important to kind of understand what is the bail system in the United States. And so the way the bail system works is an individual gets arrested, and very shortly after that arrest, they're going to have some sort of bail hearing. And so this is usually supposed to happen within 24 hours. And so these bail hearings are very short, and many times they're about 3 to 5 minutes each. They're often now held on video conference, so just like this, there'd be a bail hearing with a judge in a different room and then the defendant on the video. So what happens is the case and defendant information is presented to a judge, and the type of information they get is, things about the defendant's past crimes, some preliminary evidence of the charge, maybe some basic demographic information, and then they're allowed to also ask questions of the defendant. And so kind of a interesting feature of this setting is that judges are just given considerable discretion when setting bail. And so they have a few different decisions. They can, kind of the most common things, because a lot of crimes are relatively minor, they can release without any conditions. So this is just, you release an individual, they don't have to do anything to be released, they just promise to come back for future court dates. In the United States, many jurisdictions also use monetary bail. And so what that means is they set some sort of bail amount. And in order to be released, you need to pay 10% of that total amount. And so you pay that 10% and then you're released. And if you do something like forget to go to a court date, or if you participate in further crime, you're going to forfeit that 10% of the bail you released. So it's meant to be something that incentivizes people not to participate in further crimes or to miss future court dates. However, the effect is oftentimes defendants are unable to obtain even relatively small monetary bail amounts. And so what happens is they end up being detained before trial. And so in many places, you have a relatively large fraction of individuals who just are detained in jail before their trial, even though they haven't been convicted of any crime yet. So just to give you some context about, what pretrial detention looks in other countries, if you look at the pretrial detention rate per 100,000 individuals, the United States is kind of an outlier. And so they have much higher rates of pretrial detention than any other country. And most of this is thought to be due to kind of the heavy usage of monetary bail, which results in individuals being detained because they just can't obtain a relatively small amount of money. So why does this matter? Being held on trial has enormous consequences for the individuals that are detained. And so this is work by some of my co-authors that looked at, what is the effect of being detained before trial? And what they did is they used kind of this variation across judges. So some judges are really lenient, they release almost everyone. Some judges are very strict, they detain a lot of people. And so kind of by the luck of the draw, you can say you can be released versus detained. And so they use that kind of variation across judges to see what is the effect on these defendants that are kind of randomly detained. So what happens is they have much higher chances of being convicted of the crime because they often will plead guilty in order to get out of pretrial detention. Many of them lose their jobs, so they have a significantly higher probability of unemployment after the trial. And then if you kind of take a total summary of how much earnings they lost, it's approximately $30,000 in lost earnings in government transfers. This is due to losing some government transfers due to being convicted of a crime, as well as not being as likely to have a job. So this is a situation where racial disparities in detention rates will have enormous consequences because detention itself is a very impactful event for a defendant. And so if you kind of look in the data and explore what do racial gaps look like in this setting, you'll find that in a lot of jurisdictions, white defendants are more likely to be released before trial than very similar Black defendants. So this is also from some of my co-authors. They computed gaps in detention rates for white and black defendants while kind of controlling for some basic characteristics like your prior criminal history. And so you can see that every county here that has a positive means that they are more likely to release a white individual than a black individual. And so some of these are very incredibly high. So this is like a 35% gap in release rates between white and black defendants. There are some counties that have, the opposite, but if you take the average overall counties, you'll find in a lot of jurisdictions and overall that white defendants are more likely to be released before trial than black defendants. And so the question is kind of what drives these racial disparities. And so you can have kind of two stories. One is that there could be legally relevant differences between white and black defendants, or it could be due to racial bias. So in many settings, not just pretrial detention, it's a bit difficult to kind of rigorously disentangle these two. And why is that? Is because judges are observing more variables than the researchers do. So even though I control for something, the judges see more than I do, and so maybe the differences in detention rates are due to these other variables that the judges sees and not necessarily due to race. So the differences in release rates could theoretically stem from differences between defendants that we as researchers cannot control for. And so we're going to kind of exploit some key feature of the bail setting in order to kind of overcome this hurdle of, we don't observe everything. And kind of the key feature in this setting is that the judge's legal objective is actually extremely narrow. So their goal when they're deciding this is to release most defendants while minimizing the risk of pretrial misconduct. So pretrial misconduct is failing to appear at future court dates or participating in further crime. So this is really the only variable they should be considering, is kind of the predicted probability that this individual is going to behave in pretrial misconduct. And so that kind of simplifies this. It's not as if they're trying to, have any measure of is this person guilty or not. That's really not part of pretrial detention. That all comes later during the criminal courts. So this is really just saying I should assign some bail conditions for individuals who I think have a high probability of participating in pretrial misconduct. So what we can do is say, if judges are releasing white defendants with high probabilities of pretrial misconduct, while at the same time detaining black defendants with low probabilities of pretrial misconduct, they must be discriminating. So instead of looking at differences in release rates, we can look at, what are the outcomes of these individuals in terms of pretrial misconduct rates. And because that's all what they're trying to minimize, that's going to give us a sense of discrimination. And so I'll kind of go through that argument more slowly. This is a kind of one way to infer discrimination when you don't observe all the variables. It goes from, you have to observe all the variables to just observing this one legally relevant variable. So just give you an overview of today's talk. It's based on a few different papers, but the first part is going to be talking about racial bias in the Philadelphia and Miami-Dade court systems. So this is going to be based on work with Will Doby and Crystal Yang. They're both at Harvard. Crystal's also a lawyer, so she helped with, the kind of institutional details of pretrial detention. Then I'm going to discuss a little bit about algorithmic discrimination. And so what we're going to find in the first half is that there's significant evidence of racial bias in bail decisions. This is kind of one component of a larger reform in the pretrial detention. So right now, kind of pretrial detention is going through a major reform. A lot of places are getting rid of cash bail because of these kind of unfairness. And if you get a good judge, you might they might be not set as many conditions and you might get released. But if you get a really strict judge, these sort of things are kind of arguments for reforming the pretrial detention system. And one way to reform it is to replace the human decision makers who have been shown to be biased with an algorithm. And so what the algorithm would do is it would just take in inputs of observables of the individual, like what type of crime they've been arrested for, what is their prior criminal history. It would just take those variables and output a recommendation of what to do. And so This is often seen as more fair because everyone with the same observables gets the same decision. But there's been kind of increasingly amount of work talking about how algorithms themselves can also be discriminatory. So I'm going to talk a little bit like what does it mean for an algorithm to be discriminatory? If you exclude race, it seems like it would be perfectly fair with respect to race. We're going to talk about why could algorithms also be discriminatory? And then I'm going to show some evidence that this isn't just kind of a theoretical idea, but actually in an actual court setting. So in New York City, we're going to estimate algorithmic discrimination by trying to estimate one of the options to replace judges with is a kind of sophisticated machine learning algorithm that predicts misconduct rates. We're going to show that that sophisticated algorithm might be better at predicting misconduct rates than judges, but it still has significant algorithmic discrimination. Okay, so to begin, I'm just going to go through kind of this is going to start with the Philadelphia and Miami data, and I'm going to talk about what do I mean by bias in the pretrial detention. So I'm going to consider a very simple model of how these judges are making the decision, and their decision is going to be based on just two parameters. So the first parameter is that the judge needs to predict what the risk of this individual is. So I'm going to say that the risk of a given individual is P. So for example, if P is equal to 0.5, then this judge is predicting that this individual has about a 50% chance of behaving in pretrial misconduct. And so what the judge is going to do, it's going to choose a threshold and going to release all defendants if the individual's predicted risk is beneath that threshold. And so the key here is that the threshold, which is given by T, is allowed to depend on race. And so what the judge is going to do is going to predict risk with P, and then look at the judge-specific threshold T and say, if the risk is less than T, then I will release this individual. So for example, if the threshold is 50%, then any defendant that has risk less than 50%, as determined by this judge, will be released. Any defendant with risk above 50% will be detained. And so what we're going to define as racial bias is if the judge is choosing different thresholds by race. So if, for example, T sub W here is greater than T sub B, that means the judge is holding Black defendants to a stricter standard than white defendants. It's going to be the threshold is lower for Black defendants. So for example, if the threshold is 0.4 for Black defendants, then any Black defendant with risk above 0.4 will be detained. If it's 0.6 for white defendants, then any white defendant with risk above 60% will be detained. And so that would be a that would be our definition of racial bias. It'd be that 0.6 threshold minus that 0.4 threshold. So just to give you a bit more intuition of what we're trying to identify here, I'm going to go through kind of pictures that show the same words that I just showed. So you can imagine each judge has some sort of sees risk of different defendants. And so this kind of gray curve right here is what I'm saying is the distribution of risk for this judge. And so the fact that the hump is towards the middle is saying most people in this population are basically average risk. So we could say this is 0.5. We're saying most people are about average risk. There are some individuals that are very low risk. And there are some individuals that are very high risk. The judge is just going to place a threshold in this distribution. And so everyone below, the risk is on the x-axis, everyone below this threshold is released. So this judge is releasing half the defendants because half the mass of the distribution is to the left, and is going to detain all the defendants with risk above the threshold. So half the defendants are detained because their risk is above this judge-specific threshold. And so if we want to look at racial bias, what are we going to want to identify is we want to identify what are these race-specific thresholds. So you can imagine, getting different different defendants with different risk probabilities. So say I see a white and a black defendant, and they both have a 20% chance of being of participating in, in pretrial misconduct. I've labeled 40% here and 60%. So 20% would be about here on the x-axis. And so that's beneath both the black threshold and the white threshold. So this defendant is released no matter what. 20%, person with 20% is released no matter what. However, as we get closer to 0.4, we're kind of getting on the margin of release for black defendants. So for example, if we take an individual that's 50%, if that individual is white, they are beneath the white threshold, so they're released. But if that individual is black, they're above the black threshold, so they're detained. So all the individuals between these two thresholds are detained if black, but released if white. And so differences in these thresholds is going to reflect racial bias. So the idea in the paper is that the goal is to identify these thresholds. And what do we want to do? One way to do this is to say, let's find everyone that's just right on the margin of being released. What is the risk of those individuals? So that's going to end up being what we're after, but it's actually going to be kind of a very difficult object to identify when we actually look in the data. But you should keep in mind, this is kind of the end goal, to estimate these thresholds. So just to give you some context for this idea, this is actually a very old idea in economics. It originated in a paper by Gary Becker. So it's actually a book. So Gary Becker was a Nobel Prize winner. And the idea was originally proposed as a way to test for bias in loans. So the idea was, we see differential loan rates for white and black households, but we don't know if that's due to racial bias or due to different observables, for example, like income and debt. So his idea was, don't look at loan rates, but look at the profitability of those loans. So if individuals are being biased towards black households, then they will only loan to a black household if they're very likely to repay their loan. And so if you look in the data and find that all the black households are repaying their loans, but some of the white households are not, that's going to be evidence of racial bias. So just like in this setting, if you look at the white defendants and they're behaving in pretrial misconduct a lot, but if you look at the black defendants and they're not behaving in pretrial misconduct, they must be holding the black defendants to kind of a higher standard due to racial bias. So this is kind of the intuitive idea, but it's actually very hard to apply because of something that's known as inframarginality bias. So what that basically means is that we actually we don't want to look at the average rates of misconduct. We just want to look at the kind of misconduct rates for the very last person that's released for each race. And that's what's going to identify the thresholds, not these average misconduct rates. And so this is kind of the hurdle we address by trying to say, how can we actually identify marginal defendants in the data? And so this is kind of a subtle point, but just to try to give you a bit more intuition on what is inframarginality bias. The idea is that what we generally see in the data are actually average misconduct rates. So imagine if we see released white defendants behave in misconduct at a rate of 20% and released black defendants behave in misconduct at a rate of 30%. If we kind of naively apply the outcome test, what we might conclude is, okay, white defendants seem to be relatively low risk. So maybe they're holding white defendants to a very low threshold. Black defendants seem to be participating in pretrial misconduct more. So maybe their threshold is actually quite high. So that is actually not the right conclusion though. So you can actually show that in this case, you can't really conclude anything about bias. And the intuition is that by looking at the average rates, we're kind of missing what the thresholds are completely. So for example, in this example, it could be that judges are actually allowing very high risk white defendants to be released, but it just so happens that there's a huge mass of white defendants that are very low risk. So that means they would be willing to release higher risk white defendants, but you just, by looking at the average, you're getting a lot of low risk white defendants. And so then you're not actually getting the threshold correct. And so then this could be, in this situation, it could be bias against either race or no bias, and we don't really know without further information. This is just to underscore, to identify this threshold, we really need to estimate the risk of defendants at the margin of release, not for all the defendants. And so in this paper with Will and Crystal, the key idea is that we can use variation across judges to identify what are the marginal defendants. So for example, you could have two judges, and the first judge releases 50% of defendants, and then judge 2 releases 51%. And so what does that mean? It means they kind of disagree on 1% of the defendants. And so we're going to call these 1% that they disagree on kind of marginal defendants. So therefore, we can implement the Becker outcome test by estimating what is the probability that these individuals that these judges disagree on behave in pretrial misconduct. That will kind of give us the risk of marginal defendants. So in the data, we don't actually see, we don't have multiple judges making decisions for the same defendant. So this is all kind of a statistical argument that if you have certain assumptions, like they're seeing the same types of defendants and they agree on the ranking of the probability of misconduct, then you can do this in a statistical sense. You can back out what the marginal risk of the defendants. There's actually a lot more details here, but this is kind of intuitively what the procedure is implementing. It's estimating the risk for everyone the judges disagree on. Just talk about the data a little bit. So this is administrative data from court records from Philadelphia and Miami. So what you get with this data, you get the kind of basic background characteristics such as name, race, birth date, gender, zip code, and then some characteristics of the actual given offense. For example, the offense severity, the date of the offense, and as well as an identifier for what judge this individual saw. And so that's going to be a key variable. We know what judge the person is assigned to. And kind of an interesting feature of this setting that is really kind of the key feature that we need is that judges are actually quasi-randomly assigned. And so what that means is the judge you get on a given day is essentially random. They just do it based on caseloads, and so they'll just randomly assign you to a given judge. I'm not going to go into why that's such an important assumption, but we do need that for everything to kind of work. The key variables are that we have the race of the individual, and the key outcome we're looking at is going to be rearrest prior to disposition. So that's what we kind of mean by risk in this first paper is, is this person have a high probability of being rearrested prior to case disposition, which means before their trial, they're going to go out and commit further crimes. Another key variable is pretrial release, which is defined as, is this person actually released before trial or not? So just to give you basic summary statistics about this setting, if you look on a release on recognizance, what that means is that they're released without any conditions whatsoever. And so you can see that white individuals are released on recognizance at 19.1% of the time, while Black individuals are around 17.1%. So white individuals are more often released without any conditions. They are also less likely to be signed any form of monetary bail, which is kind of the type of bail that often leads to detention. So they're around 65% of the time they are assigned some sort of cash bail, while Black defendants around 69% of the time are assigned cash bail. And conditional on that cash bail, the amount assigned to Black defendants is on average larger than the amount assigned to white defendants. So there are some kind of disparities here in the treatment of individuals. We have some these are just basic kind of background characteristics, as well as characteristics of the charge. Kind of our main variable of interest is this rearrest prior to disposition. So on average, 17.2% of white defendants are rearrested prior to their disposition, while 18.2% of Black defendants. So these are kind of the average rates, but again, they don't kind of reflect what is the misconduct rates for what we would call the marginal defendants. Okay, so the key thing we kind of need in the data is that judges actually disagree. So if this was a uniform setting, we would have no disagreement between judges. We wouldn't be able to identify who are marginal cases. But so what I'm going to show you is that first, that given that there's some discretion here, judges actually do vary dramatically in their release rates. So therefore, two identical defendants may get very different bail conditions due to just random luck. So this shows you a distribution of judge leniency. And so on the x-axis here, we have the ROR rate relative to the average judge. And so what does this mean? It means there's about, this bar is around 15%. So around 15% of judges are about 7 percentage points more likely to release defendants than the average judge. You also have on the other tail, you have about 14% here. And so these are judges that are about 7% less likely to release a defendant than the average judge. And so if you kind of go from, the most lenient judges to the most strict judges, that's an increase in release rates of around, 14 percentage points. So that means, you can get considerable differences in release rates, even though all these judges are actually seeing very similar cases. Their cases are randomly assigned. So the only reason they should have different release rates is due to their discretion. It's not the fact that these cases are somehow, less serious. The seriousness of the crimes is kind of held constant here, and this is all variation after taking into account kind of how serious the crimes are. You can also do the same thing. So this is kind of like, this is showing variation in, do you release individuals without any conditions? And then this is showing variation in, do you assign some sort of monetary bail? And again, there's kind of considerable variation across the average of 0. You get some defendants, this is about 3 percentage points more likely than the average. This is about 5 percentage points less likely than the average. So if you move defendants across this distribution of leniency, you're going to get much different, monetary bail amounts, monetary bail, and then that's going to lead to differences in release. Okay, so then this is a pretty abrupt change, but there's a lot of details that are missing. But I'll just tell you kind of how to interpret this first result. And so what this is going to be doing, it's going to be looking at those cases where judges disagree and say, on average, what are the misconduct rates for those cases where judges disagree? And so if you look at marginal defendants that are white, on average, they behave in pretrial misconduct at 23.6% of the time. So that's relatively high. So that means that kind of threshold we are after is relatively high. You look at black defendants, the ones that judges disagree on are actually very low risk. So this is kind of evidence of some sort of bias in this case. For some reason, the judges are, holding these very low risk black defendants, they're detaining them, even though they have almost 0% chance of participating in a crime or failing to appear. So overall, if you take the difference, you get significant evidence of racial bias in bail decisions. So you can also do it for different crime types. And so if you do it for drug crimes, these being positive indicates that, the marginal white defendant is more risky than the marginal black defendant. And that's going to indicate significant racial bias. So what we kind of do in the paper is think about what could be the drivers of this racial bias. And so one story is that kind of taste-based discrimination is driving them. So it could be racial animus may lead to judges to knowingly detain low-risk black defendants. But what we find in the paper is that actually both black and white judges tend to be biased against black defendants, and bias varies among subsamples of the data where it's unclear why racial animus would vary. So these results are inconsistent with most taste-based models where the kind of racial bias is driven by some sort of animus. What we think seems to be going on, or is more likely, is that they have these sort of race-based prediction errors. So it could be that judges are using race as kind of a heuristic, and it leads them to unknowingly detain Black defendants at higher rates and unknowingly detain Black defendants that are actually very low risk. And so bail judges do make very quick decisions. They have very limited information. It's often described as kind of an amateur link in the criminal justice system. So what we do is we kind of examine some testable implications of race-based prediction errors. So what we do is we look at variation across the courts that we have. So if you look at, we had Miami and Philadelphia. And so kind of the interesting thing is that in Miami, all these judges are not full-time bail judges. What they do is they help out bail in certain times, but their main job is criminal courts. So you have kind of inexperienced bail judges coming in. They make a few hundred decisions about what to do with these defendants, and then they kind of leave for the rest of the year and then maybe come back a year later. In Philadelphia, all the judges are full-time. This is what they do for a living, and they have thousands of cases. And so if you look at racial bias within each jurisdiction, kind of all of the racial bias is stemming from Miami. So a positive value here means the marginal white defendants are more risky than the marginal Black defendants. So you can see in Miami, this is the part-time Miami judges. There's significant racial bias, but if you look at the full-time Philadelphia judges, it's basically zero. It's not significant. There's no evidence of racial bias in Philadelphia. You can further split it up within Miami. And so some of these judges have just started doing this, kind of helping out the bail detention, while others have done it a number of times. And so we kind of split by the median caseload. So some judges have, thousands of cases in Miami still, even though they haven't, this isn't their full-time job. So we can look at bias for the kind of high experience Miami judges, and we can also look at bias for what we call low experience Miami judges who have just started. And kind of the bulk of the bias is driven by these low experience Miami judges. So these kind of like two facts are consistent with experience being an important source of bias here, that they aren't good at predicting these outcomes, and what that translates this to is that they detain low risk Black defendants while releasing relatively high risk white defendants. So that's kind of the, this is kind of the transition to the next part of the talk. And so kind of given this potential room for inequities in bail, not even looking at race necessarily, but just looking at, variation across judges, and then compounded by the fact that there are just these huge racial disparities, this has kind of driven a reform of saying, are there better systems than cash bail? So most notably, New Jersey has eliminated cash bail. California passed a law to do the same, but it was actually repealed in the prior referendum that just occurred. And what a lot of these proposals do, some of them are quite unclear on what they're going to replace the system with. So you need to kind of figure out exactly what they want to replace cash bail with. But a kind of a common element of many of them is to replace it with some sort of predictive algorithm. And so these predictive algorithms are actually already used in many places as an aid to judges. So for example, the next part of the talk is about New York. And so in New York, they have a risk assessment program where they have, I think it's 6 to 8 variables. And based on the answers to those variables, you get a risk score that's 1, 2, or 3. And so 3 means you're very high risk, 1 means you're not high risk, and they give these to judges. The judges can simply ignore them if they want. In many cases, they do ignore them. But it's kind of already used in the justice system. People have thought about how to predict misconduct. So there's actually good evidence that they do perform better than judges. So there's recent work saying, what's the best we can do? Let's use the most kind of state-of-the-art predictive algorithms to try to predict misconduct. Can we do better than judges? And the answer is yes. They can improve the performance significantly. And so it's a potentially good policy proposal where you can have lower crime rates because the algorithm's better at predicting who will participate in crime. and less detention because the algorithm does not detain low-risk individuals. There's a big fear, though, that not just in pretrial detention, but also in other settings, that algorithms will reinforce past disparities. So this is kind of most obvious in actually settings outside of bail. But if you kind of train an algorithm on data that itself was generated by biased decision makers, then that might inflict some bias into your data. So for example, if you were hiring job applicants and the people who were hiring for the positions were discriminating towards Black applicants, then the algorithm will say, the Black applicants are generally not interviewed and not hired, so they will say, don't interview this individual. So that's how kind of past bias can get into future algorithms if you train the algorithm on past data. We're going to talk about a somewhat different source of algorithm discrimination in this particular setting, because we're going to be trying to predict misconduct. And so in the last paper, we explored bias, which means different thresholds by race. So people are held to different standards. There's also statistical discrimination. If you've taken the discrimination class, you may have talked about these differences. But what statistical discrimination is that you use predicted characteristics such as race to form predictions. And so this is different because you could apply the same threshold by race, but you actually use race to form your prediction. So then that can generate discrimination even if your thresholds you place are risk neutral. And so what you can do with an algorithm is you can force it not to include race. So then that seems like it's not using race to form predictions, but that's actually not true. So they may statistically discriminate even if race is not included in your algorithm. And so how can that happen? Is through proxy effects. So imagine I'm designing a kind of predictive algorithm for pretrial misconduct, and I decide that an individual's zip code is something that should be included in the predictive algorithm. Many zip codes are kind of highly segregated, and so zip code of residence, even though it's like seemingly race neutral, two individuals with the same zip code will have the same impact in the algorithm. It might be highly correlated with race in many settings. So even though you don't give the algorithm race, it can replicate race by using different variables that are correlated with race. So this is what we mean by proxy effects, that even though if race is not an input into their algorithm, zip code may be used as a proxy for race, and therefore it's as if you're using race to predict pretrial misconduct. So what that can do is lead to statistical discrimination. And so this is a recent ProPublica article that really highlighted this possibility. And so it looked at a software that's used across the country to predict future criminals. And it looked at, what are the risk scores for Black defendants? And so the risk scores go from 1 to 10. And you can kind of see that there's kind of an even number of individuals in each risk bin. If you instead look at white defendants' risk scores, you can see that there's many more white defendants at low risk scores and not so many at high risk scores. And so it seems like the algorithm is predicting that the Black defendants are higher risk on average than the white defendants. So this is a recent, so the next part's about a recent paper with Will Dovey and Peter Hull, where we kind of try to develop new tools in order to measure racial discrimination in algorithms. And so we implement this in New York City. So what we do is we kind of say, let's take a sophisticated risk assessment tool that might be kind of the state of art used to replace judges and see if there's any discrimination. And so what we do find is that algorithm recommends releasing white defendants at about 7.9 percentage point higher than Black defendants with identical misconduct potential. So I'll get in a little bit detail of what does identical misconduct potential mean right now. So it says, even though we saw that the risk scores were different between white and Black defendants, it could be due to other variables. We're saying the bulk of it is actually due to kind of statistical discrimination of the algorithm. So how do we measure algorithmic discrimination? This is going to be kind of lacking a lot of the details, but what we mean by the definition of algorithm discrimination is that the average disparity among equally qualified white and black defendants. So what does equally qualified mean in this context? It means they have the same potential for pretrial misconduct. So what we're thinking of is that, all individuals, if they're released or detained, have some sort of latent pretrial misconduct potential. So you could imagine taking all individuals, if you could identify this, individuals who will behave in pretrial misconduct. So there's no kind of differences in the unobservable variables because we're taking everyone who will behave in pretrial misconduct. Do these people actually get the same recommendations by the algorithm? By race. So that's our measure. And so they may not, just because of, even if race is not included in the algorithm, there could still be proxy effects. So you could get different recommendations for individuals of the identical pretrial misconduct potential. So what we do in New York is we have a sample of, this is kind of one of the biggest pretrial detention settings court systems in the US. So we have around 500,000 cases. This is around 300,000 defendants, and there's a lot of judges, so around 250 judges. So we have some key variables. We have race, we have whether this individual is released before trial, and we have pretrial misconduct, which is either failing to appear at future court dates or being rearrested prior to disposition. So what we're really going to do is we're going to use a rich set of case and defendant observables, which includes things like the age of the individual, the type of crime they're being arrested for, a number of things summarizing their criminal history. So we have around 38 observables. And we're just going to put this into kind of this most sophisticated machine learning that we can think of to predict pretrial misconduct. And we're going to say, hypothetically, if we replaced judges with the algorithm, would there be any disparities with respect to race? And so what we find is actually there are still significant disparities by race, and it can't be explained by actual differences in unobservables. It's going to be due to some sort of statistical discrimination from the algorithm. So what this curve does, I'll just draw your attention to the orange curve that says disparity from discrimination. This is plotting the white-black release rate disparity across different algorithms' release rates. So on the x-axis, we can say, there's no set release rate that the algorithm has to achieve. You can say you can release as many or as few defendants as you want with the algorithm. But for example, this dotted line here, dashed line here, is the average release rate in New York City. So it's around 73%. About 73% of defendants in New York City are released. So what we can do is say, let's design an algorithm that releases 73% of defendants. The way it will do that is it will predict risk for every single defendant. It will sort the defendants based on their predicted risk and just choose a threshold so that 73% are released. So that's exactly what we do. We get a predicted probability for everyone. Then we just enforce a threshold that has 73% of the defendants released. So if we do that, we can then look, what does the algorithm say to do for white versus black defendants, conditional on, their latent misconduct potential. The real bulk of the paper is trying to figure out how to condition on latent misconduct potential, given it's an unobservable. But if you, kind of trust the idea, this is saying conditional on true misconduct potential, the algorithm is recommending releasing white defendants at a 7.6 percentage point higher rate than black defendants. So that's significant discrimination, even though we didn't allow the algorithm to have race in it as an input. So this is just to conclude that, kind of the takeaway from both talks is that there's kind of significant unfairness in the pretrial detention setting. So both across defendants based on what judge they're assigned, as well as most significantly across different races. However, kind of a really promising avenue forward is to replace judges with risk assessments, which, may seem more fair, but they can also be discriminatory in sort of non-obvious ways. So kind of a future work needs to understand how can we reduce discrimination in judge decisions? That's one avenue. We can give them more information. We can alert them of their bias towards different subgroups, and hopefully that would correct some of the disparities we see. Or we can design algorithms that we can make sure are fair with respect to how they treat protected classes. So not just race here, but you could also think of it as you need to enforce some sort of fairness with respect to gender or age. And so that is the conclusion of the slides. So if there are any questions, I'm happy to take questions now.
Yeah, I actually have questions about finding the marginal cases, comparing like one judge versus the other. How exactly does that identify? Is that because like the judges are like quasi randomly assigned to cases, so like they should agree on all the cases?
That's exactly it. Yeah.
Okay.
The assumption you need to make in order for this logic to go through is that they get the same type of cases. So it's quasi-random assignment. And two, they theoretically agree on the ranking of these different defendants. If those aren't satisfied, then that first part of the paper will not necessarily identify marginal defendants, because you're not looking at the next defendants to be released. You might be looking kind of randomly. So those are kind of the two assumptions you need in order to for that logic to go through, since we don't actually see two decisions for the same defendant.
So you don't get like other judges' opinions about a case. It's just this assumption.
No, it's just the assumption that they kind of agree on the ranking. So it's actually not a tremendously good assumption, I would say. It's unclear how it affects the kind of main takeaway. It probably doesn't affect it too much, but it is an assumption of the method. And so it's commonly referred to as the monotonicity assumption. So it's kind of if you know, kind of instrumental variables type approaches, that is kind of baked into all of them. And what that assumption means in this particular setting is that judges agree on who should be released in what order. But some judges they don't agree who should be released overall, but they agree that if you force them to change their thresholds, they would pick the same defendants in terms of that ordering. So yeah, they would have to be like, if I think one is the most likely to be recidivated, the other person also must think defendant one is the most likely person to recidivate. All right, any other questions?
I actually have another question if no one has any other questions.
Sure.
Do you think that like moving towards like algorithms and bail decisions is like the right move?
I'm not, yeah, I would say there's certainly arguments for it. So there's a paper by a number of co-authors that show that it's much better at predicting who is going to recidivate. And so what their kind of main point is that we can lower detention rates, or we can keep detention rates lower and we can really lower crime a lot if that's what your goal is, or we can lower detention rates and have crime not go up at all. So those both seem like good outcomes in that sense. So I think that is quite promising. Also, there's an argument to be made that, judge decision making has been shown to be biased, and it's very difficult to understand where the bias is coming from, and therefore difficult to understand how to correct it. And so there might be an easier path forward in designing algorithms that we can, by construction, make fair, rather than trying to figure out how to change the behavior of biased judges. So I would say those are two good arguments for thinking more about algorithms, but I do think it also depends on how they're implemented. So like one thing that, isn't clear from when we design the algorithm is what percent of individuals should we release? And that's still kind of a policy decision that we can't really provide too much guidance on. And so, for example, we can release the same amount and get less crime, or we can, but I don't know where on this curve of release rates we should be. I think the most literature would say we should be releasing more defendants because they are detaining some relatively high risk individual, or they're detaining relatively low risk individuals many times. And these just have enormous effects on the defendants. So it doesn't seem like a particularly fair system at the moment. And so if you design an algorithm that is really good at predicting and releases more, that might be a step forward, but it has to be kind of carefully designed. Some of my co-authors are running, are trying to, implement some of these, some proposals to improve pretrial. They're mainly working on kind of the simplest thing to do is to, instead of setting monetary bail conditions, you just send people reminders of future court dates. So that's actually a big reason that individuals are detained, is because they think they won't appear at their court date otherwise, or why they get monetary bail and eventually become detained. And so just simple reminders have been shown to be very helpful. And so that seems like something that's a win-win-win, because you have less detention that's not impacting individuals as much, and you increase your, you decrease your failure to appears, and it's very cost effective. So that's something they're going to be looking at to see how much that can improve things in pretrial detention. All right, any other questions?
I don't think there are any other questions, so I think we can end this here. Thank you so much for coming and giving this talk.
Oh,
this
no
has
problem.
been really interesting.
Happy to present. Thanks for inviting me.
All right. Yeah, so
I'm
I think
I'm
gonna end the meeting here. Thank
Okay.
you guys for coming.
Thank you.